Hello everyone, so welcome back to my English law channel. Continue with criminal law, and now I propose to look at involuntary manslaughter. Manslaughter is killing a human being, but it's less of a crime than murder. So we're going to particularly examine unlawful act manslaughter and gross negligence manslaughter. Um, anyway, so there was an important case, the Attorney General's reference, number 3 of 1994, Department of Public Prosecutions against Newbury and Jones. So here it was laid out that in unlawful act manslaughter, there are four vital elements. Firstly, that the defendant must commit an act intentionally. Second of all, the act must be illegal. Third of all, it must be dangerous. And last of all, it must be causative of death. Right? So if this can't be committed by omission, and if you did something lawful that was dangerous, that was intentional, and that resulted in death, it can't be unlawful act manslaughter. That's why there's a clue in the word unlawful. If you did something that was unlawful, you did it deliberately, it ended in death, however, it didn't seem to be jeopardizing anyone, then it doesn't count. Then it's not unlawful act manslaughter. Okay? And you can't have attempted manslaughter. There's attempted murder, but not attempted manslaughter. So let's look at this intentional act. This is about doing something on purpose. It's not about the result of what you did. Okay, so it was voluntary. You weren't forced to do it. And it wasn't accidental. You may not have wished a person to die, but the action which led to the person's death was done purposefully. So the liability must be based on a positive act. As I said, it cannot be by failing to do something. So this was decided in R against Lowe. So the unlawful act, it must be a breach of a criminal law. It cannot be civil wrong. That was found in R against Franklin. A tortious act is insufficient to count as this unlawful manslaughter. And again, the liability cannot arise from negligence, as in Andrews against DPP. There are other types of manslaughter where negligence could operate, gross negligence manslaughter, but not this one. So remember, you have to have all four aspects of there that must be present in order for this to be proven, this unlawful act manslaughter. 3 out of 4 will not suffice. Okay, and this was this was propounded in R against Lamb. There are various defences to this accusation found in R against Scarlett. Even if you did all 4 acts, there's a slender chance that you wouldn't be found guilty of manslaughter. So the act must have been perilous. And this is found in R against Church, where it was said, the unlawful act must be such as all sober and reasonable people would inevitably recognise must subject the other person to at least the risk of some harm resulting therefrom, albeit not serious harm. Close quotation. Okay, so anybody in his right mind would realise this is going to hurt somebody. You might think it'd be quite minor hurt, but you will never recognise it's going to damage the person's health or well-being to some extent, but then it ends up actually killing the person. If an ordinary person wouldn't have expected harm to arise for this, then that element is not made out, and it's not this sort of manslaughter. So what type of harm are we talking about if it's perilous? Well, it must be a harm of a physical nature, as was found in R against Dawson. Lord Justice Watson said, no sensible reason why shock produced by fright should not come within the definition of harm in the context. Shock can produce devastating and lasting effects, for instance, upon the nervous system. That is surely harm. Stop there. So shock is held to be physical harm, not just psychological. R and Watson is also about this. Okay, so you don't have to foresee, the reasonable person wouldn't have to foresee all the types of harm which led to death. So remember, it has to be imperiling someone. And what would the knowledge of a reasonable person be in this situation? Imagine the reasonable person was in the situation of the defendant. Would he perceive there to have been some danger created by the act? Well, if the answer is yes, then that's a step towards previous manslaughter. And that was found in R against Dawson. So the knowledge that would become clear during the unlawful act might be sufficient, and that was determined in R against Watson. So we also think about any special knowledge the defendant had before and during the unlawful act. That's as R against Fowler. He might know more than a reasonable person, which would actually just inculpate him all the more. So the jury don't need to consider any errors committed by the defendant as an R against Ball. These will not exculpate him. So let me give you a synopsis of the dangerous aspect of it. I said harm means harm of a physical character, although shock counts as that. Second of all, the harm has to be foreseeable by a reasonable person, but it doesn't have to be the harm that will actually eventuated. It could be another sort of harm was foreseen by a reasonable person, but nevertheless it's sufficient that a reasonable man would have thought that harm would arise. A reasonable person, assuming this reasonable person knows everything that the defendant knew at the time that the crime was committed, and assuming that this reasonable person knew what the defendant knew at the time. And bearing in mind that the man in the Clapham omnibus doesn't make unreasonable mistakes. He can make reasonable mistakes. That's different. So much of this hinges on that slippery concept of reasonableness. Okay, and another thing is that the act must result in death. If it doesn't, then that's not manslaughter. If the act causes very minor harm and death happens because of something else, well, then it's not manslaughter. So the usual rules about causation are applicable here. So there's causing death by supplying illegal drugs. There's R against Kennedy, number 2. Where they had to act, was this an unlawful act? They looked at Section 23 of the Offences Against the Person Act 1861, providing a noxious thing to someone, which resulted in death. It was against the Misuse of Drugs Act 1971, about supply of a controlled drug, Section 4.3a. Supply of controlled drugs, they're generally illegal because derivatives of opium and cocaine are legally prescribed in hospitals as palliatives or things like that. Causing death by giving someone a drug illegally, well, that's the actus reus of murder under Section 23. Of manslaughter under Section 23 of the Offences Against the Person Act. So that would be causing another person to administer to himself a poisonous substance. So we have to ask whether it's suitable to find someone guilty of manslaughter if he gives somebody else a Class A drug, and that person, of his own free will, takes the drug and dies. Because here we see someone who's informed and who's an adult who's deciding to take this drug. So it's held that the chain of causation is broken. Doesn't seem quite right to me, but there we go. So coming on to gross negligence manslaughter. R against Adamarco is a key case here, whereas an anaesthetist, he wasn't paying attention. The oxygen supply was cut off to his patient, who died as a result. Now, but for the anaesthetist's inattention, the patient would have lived. So there are 5 elements we have to find here for gross negligence manslaughter. First of all, the defendant must owe a duty of care to the victim. Second of all, he must have been in breach of the duty to the victim. Third of all, that breach must lead to death. Fourthly, there must have been a clear risk of death arising from negligence. And last of all, the breach of this duty must be gross negligence. It can't be minor negligence, because many professionals are a little bit negligent, but this has to be much more serious than that. So the duty of care, so that there are rules about negligence. There's R and WACA, for example, and you can be held liable for omissions here. So this is a crime that can be committed by omission, where you have a responsibility to act, parent to child, doctors, nurses, and dentists to patients, sometimes police officers and so forth. Even the police. So there are instances of manslaughter by gross negligence which arose from failing to act, such as an R and Singh, R against Ruffle. So, as I say, the usual rules of negligence are applicable in this case. We know what causation is, possible there be novus actus interveniens. There must have been a blatant risk of death. That's found in the aforementioned cases in R against Misra and Srivastava and R against Rose. So it must have been a palpable chance that someone was going to die if the duty was breached. So we have to ask whether the defendant was not just negligent, but grossly negligent, as in Bateman, or also R against Adamarco. And the judge held the jury will have to consider whether the extent to which the defendant's conduct departed from the proper standard of care incumbent upon him, involving as it must have done a risk of death to the patient, was to such that it should be judged criminal. Close quotation. So if it wasn't so bad that it was criminous, then he's not guilty, because it could be a little bit bad and not still reach the criminal standard, even if that leads to death. If the negligence is trifling but leads to death, that's not manslaughter. Might have just been very unlucky that, once in a blue moon he was not fully concentrating and that led to death. Okay, so gross negligence, then more cases like R against Prentice and Sorman and R against Litchfield. Anyway, so we have to ask whether the defendant's errors are partially or completely brought around by acts or mistakes of others, and that might be why someone's found not guilty, such as in Prentice and Sorman. So yes, the defendant committed a mistake, was a bit negligent, however, it's cumulative, many other committed trifling mistakes, and no one person is culpable of a felony. Now, there can be cases where gross negligence by the defendant make him guilty, even if others are partly responsible for the events which caused the death. But if the defendant has personal responsibility and is able to discharge that responsibility, he'll still be found guilty, as in R against Singh. So we have to bear in mind the experiential level and the skill, the qualifications of the defendant. The higher those are, then the more culpable he's likely to be. An extremely experienced surgeon is not the same as a very hard-pressed nurse, for example, within her first year. Okay, so you don't need to have any particular mental state. This was found in R against Adamarco. But if the defendant realised that there was a significant chance of causing death, then this is indicative of gross negligence. Litchfield found that as well. So that's just a little bit about this very thorny issue. So please subscribe to my channel, book online law lessons with me, George from Ireland. Bye-bye.